Your Honour, Simmons, initial essay for the applicant, Darren Smith, regarding section 590, capital AA of the Criminal Code, an application made under subs 2E, which is provided for the removal of such evidence as the interview with Detective Walsh as inadmissible, and that sub 3 provides for the special reason to give leave to reopen the ruling as such factors I will advert to show the reasons that I believe that are relevant here. The Police Powers and Responsibilities Act 2000, the PPRA, these sections were triggered: 398, 403, 412, 414, 416, 418, and 419, and a possible 423 being that there may have been some incapacity from toxicity of either drugs or alcohol. There's no swab test or blood test regarding. And also S10 of the Criminal Law Amendment Act 1894 was triggered also. Special reason constituted by the lack of free will, inability of coherency, such as lack of sleep, the common law basal principle of intimidation, inducement, fear, bribery, such as the food and sleep. Also, the time factor is questionable, Your Honour, and influences which come to the drugs again. The incident was a drug deal, so the applicant, Mr. Smith, may have been on some form of drugs. Also, the discretion here, Your Honour, to do with McDermott and the King at 511 of the judgment, Dixon J. at common law says a confession or statement made out of court by an accused person may not be admitted in evidence against him upon his trial for the crime to which relates unless it's shown to have been voluntarily made. This means substantially that it has been made in exercise of free choice. If he speaks because he is overborne, his confessional cannot be received in evidence, and it does not matter by what means he has been overborne. If this statement is the result of duress, intimidation, persistence, importunity, or sustained or undue instance or pressure, it cannot be involuntary. S10 Criminal Law Amendment Act raises the trigger here, Your Honour. The basal principle under Ingham and the King 1914 case at 609 and 610 of the judgment. Also 403 sub 2, the 8 hours detention raises a question here. How long was he detained for? Basically, when he's also got the 4 hours under 403 and sub A, where Detective Walsh has breached that to some length, or there's very, very, I suppose, shonky sort of recordings of how long he's been detained for, since the indictment was at one point of time and he was then talking about being reprimanded. Also, I understand that it's a serious crime, being murder. Also, Your Honour, the combination of factors which constitute special reason for opening the trial exercise the court's discretion under sub 3 of 590 capital AA. Detective Walsh's conduct and the failure to acknowledge the retainment of the lawyer, Miss Faison, raises great question. Mrs. Smith called the detective and mentioned that Mr. Smith had retained representation, so it comes to question why there was no conversation between Detective Walsh and Miss Faison, considering as to why there's no format of that. Stating also that the eagerness for the conviction raises a huge question here in the protocols with Detective Walsh. The failure here to provide the information in the conducting the interview under 416, but the failure is his duty here, Your Honour, is that Miss Faison, as Mr. Smith's represented as counsel in his whereabouts, as in 418 sub 1A and B, in also to actually then also delay the actual questioning under sub 2. and await Miss Vison's arrival under sub 3 of 418. That raises the question as to the length, that there was no conversation about how long Miss Vison would take to arrive, and that the reasonable practicable time would be up to 2 hours. So that raises the question there, Your Honour, that there was no freely given confession statement. The other issue here is Detective Walsh was aware of the factor but still interrogated. It is under the point here that the decent feed and that he hadn't eaten properly in days would also constitute some form of inducement. And undoubtedly, under 403(2), you can only detain a person for a maximum of 8 hours, and an interrogation of 4 hours under 403(4)(a), which shows that the remand statement constitute a threat of abuse of the authority by Detective Walsh, not instructing Mr. Smith about his statutory requirements and duty to actually engage that Mr. Smith has representational counsel by Miss Vison. Your Honour, you should exercise your discretion regarding the confessional statement, as it should be rejected because the special reason here to do so outweighs any public policy grounds, because the confessional statement was obtained unlawfully, and in reviewing all the circumstances and considering that Detective Walsh's acts were irreprehensible, and by not exercising your discretion in determining that the confession as inadmissible will constitute a miscarriage of justice, placing the administration of justice into disrepute, because I don't think any public would actually justify that such acts by Detective Walsh would actually constitute something that would be for the public good, other than that the protocols are in place to actually uphold and enforce the law. Thank you, Your Honour.